31st, 2026. 10 days ago, a court in Munich, Germany handed down a ruling that every single person who creates anything needs to understand. 6 songs. That's all it took. GEMA, Germany's music licensing agency, walked into court with 6 songs. Forever Young by Alphaville. Mambo No. 5. Daddy Cool by Boney M. Rasputin. They typed simple prompts into Suno, the AI music generator valued at $5.4 billion. And what came out was not new music. It was songs that matched the melodies, harmonies, and rhythms of copyrighted tracks. The machine had memorized them. The court ruled Suno broke the law, both German law and United States law. And here's why this matters to you, even if you've never opened Suno in your life. This ruling didn't just say Suno needed to pay up. It dismantled the single most important legal defense every generative AI company has been hiding behind. And I'm going to explain exactly what that means. Because in my 19 years of legal practice, 15 of them in intellectual property, I've watched copyright law evolve. But I have never seen a ruling with implications this wide. Let me take you inside the case. Why this matters now. Before we get to the ruling itself, you need to understand what Suno actually admitted. In a separate court filing in the United States in 2024, Suno's own legal team wrote, and I'm quoting directly, Suno's training data includes essentially all music files of reasonable quality that are accessible on the open internet. Read that again. All music files of reasonable quality on the open internet. That means every song on YouTube, every track on SoundCloud, every independent artist who uploaded their music anywhere. Suno took it, trained on it, built a $5 billion company on it, and didn't pay a single cent in licensing fees. Now, Suno's defense, and this is the defense every AI company uses, goes like this. We're not copying. We're learning patterns. Just like a human musician listens to music and learns what a chorus sounds like, our model learns statistical patterns. That's fair use. It sounds reasonable until you test it. GEMA tested it. They prompted Suno to create music, and what came back wasn't inspired by those 6 songs. It reproduced their core musical elements so closely that the Munich court found Suno had, and this is the legal term that matters, memorized and reproduced protected works. Memorization, not inspiration, not learning patterns. Memorization and reproduction, that is copyright infringement. How? The court proved memorization. Let me walk you through how GEMA actually proved this. Because the method matters. They didn't need to hack into Suno's servers. They didn't need a whistleblower. They simply used Suno the way any user would, by typing prompts, and documented the output. The prompts were basic, things like create a song in the style of 1980s synth pop with a melancholic melody. And what Suno produced contained melodic fragments, harmonic progressions, and rhythmic patterns that matched specific copyrighted songs in GEMA's repertoire. Now here's where it gets legally devastating for Suno. Suno argued 3 things in its defense. The court rejected all 3. Defense number 1, we only learn patterns, we don't store songs. The court said, if prompting your system can reproduce protected melodies, the distinction between learning patterns and storing copies collapses. The output is the evidence. If it walks like infringement and quacks like infringement, it's infringement. Defense number 2, it's fair use under US law. The court looked at the 4 factors of fair use: purpose of use, nature of the work, amount used, and market impact, and found that training a commercial AI on the entirety of the world's music to create a competing product fails on every single factor, especially market impact. Suno doesn't complement the music market, it substitutes for it. Defense number 3, the user wrote the prompt, so the user is responsible. The court said, no. The infringement happened when you trained the model without a license, not when the user pressed generate. The training is the violation. The output is the evidence. 2. Why this ruling changes everything. Now, if you're thinking, this is one court in Germany, why does it matter globally? Let me connect the dots. First, this is GEMA's second win against a major AI company. In November 2025, the same Munich court ruled against OpenAI for training ChatGPT on song lyrics without license. 2 cases, 2 wins, a pattern is forming. Second, the memorization finding is the key that unlocks every other AI copyright case worldwide. Because here's the problem AI companies have. They all trained on the same internet. Suno admitted it. OpenAI's models were trained on Books 3, a pirate library of 196,000 books. Anthropic just paid $1.5 billion to settle a case over pirated training data. Every single one of them used the same defense, fair use. And what this German court just established is a method for proving them wrong. You don't need to see the training data. You demonstrate that the output reproduces protected elements. The output is the evidence. Third, this ruling creates legal precedent that AI companies must license training data before they use it, not after. Before, GEMA's CEO, Tobias Holzmüller, put it bluntly. AI models built on stolen intellectual property have no protection under the law. AI service providers must pay for licenses rather than helping themselves to our members' works free of charge. Think about what that means for every AI company, not just music, image generators, video generators, code generators, text generators. If the training data was scraped without licenses and the output can reproduce protected elements, the legal framework this ruling established applies. What this means for you. So let me bring this home to you. The creator, the musician, the writer, the person building things. If you create original work, your copyright just got stronger. This ruling says AI companies cannot simply take your work, feed it into a machine, and sell access to what comes out, not without paying you. Register your copyrights, document your creative process, because if an AI model reproduces your work, you now have a legal pathway to fight back that didn't exist clearly before July 31st. If you use AI tools, including Suno, Udio, Midjourney, or any generative platform, understand this: what the AI generates for you may not be yours. In the United States, the Copyright Office has already ruled that purely AI-generated works cannot be copyrighted. And now, with the memorization finding, there's a second problem. The output itself might infringe someone else's copyright. If the model memorized protected work and your prompt surfaces it, you could be liable. If you're in India, India's copyright law, like Germany's, does not have a broad fair use doctrine. It has fair dealing, which is narrower and more specific. AI companies operating in or serving the Indian market need to pay attention to this ruling because the legal reasoning crosses borders. What a German court calls infringement, an Indian court may very well agree with. Here's the bottom line. For 2 years, AI companies have operated on a simple assumption. Take everything, apologize later, call it fair use. That era just ended. Not with a press release, not with a policy paper, with a court ruling that says, in legally binding terms, memorization is not fair use. Training without licensing is infringement, and a $5 billion valuation doesn't put you above copyright law. The question now is not whether AI will change how we create. It already has. The question is whether the people whose work built these models will have any say in what happens next. This ruling says, yes, they will. I'm Garikapati Bulavenkaya, and this is Nezzhub Tech, where we don't just explain technology, we explain who owns it, who's liable when it fails, and what rights you're signing away by using it. If that sounds like the channel you've been looking for, subscribe, because this conversation is just getting started.